Good afternoon, everybody. We're going to get started. This afternoon's session is an area that concerns everyone who litigates these lead paint cases. It's probably one of the most important coverage cases to have been decided in recent years. And we have two great speakers to tell you about it. Todd Wilson, Todd Wilson and Mark Gaffrey. And Todd and I have litigated many of these cases together. I've known them for years, and nobody is more diligent and more thorough in their preparation and knowledge of the law than Todd is. He's with Bodie, Delina, Smith, and Hobbs? Hobbs in Towson.
Friedel.
Pardon me?
And Win Friedel.
Oh, and sorry, Win.
He's here
So, and Mark is with the firm of Hoagland, Longo, and Moran. He is been litigating toxic tort cases for over 30 years, and most recently he was involved in, as lead counsel, the most significant environmental case that has been decided in decades. It's called NJDEP versus Diamond. So you're going to hear from two people who really have an excellent background in this. The Roberts issues permeate almost every case that we hear now, at least in Maryland, and I'm sure throughout other jurisdictions. So with that, I'm going to leave it to Todd.
Brian is, as always, so gracious. Thank you, Brian. What we're going to do here, a little bit of a shift in schedule. We were originally scheduled to go an hour, but in order to make time for our esteemed judges, Mark and I are really going to cover the area here in the next 45 minutes or so. We're really going to talk about two basic issues. The first issue is, just as Brian mentioned, the Roberts case, and Mark in particular is going to talk about the case, the detail behind the case, and related issues. And as Brian mentioned, it's a real special treat, if you will, given Mark's background and having tried that case in New Jersey. Most significant toxic tort case tried, and he was trial counsel in the last 30 years. So we're going to tap into Mark's great experience on that case, first of all, and he's going to really discuss that first basic area. The second basic area I'm going to then talk about, and Mark's going to talk, I should mention, about 20 minutes. When Mark's done speaking, I'm going to then talk about the second basic area. And the second basic area is, and it's reflected, if you will, on the overhead here, which is when you take a close look at Roberts and the issues related to Roberts, it really can lead to what we affectionately call our "what the hell just happened?" And we're going to talk about that. And I'm going to give you some examples of that. I'm actually going to cover a couple of cases on that. And then the idea is we'll talk about those bad moments, what they are, and then we'll talk about steps you can take, sort of real-life steps you can take, real-life practical steps you can take that will help prevent those moments. And if issues are heading that way, then we're giving you ammunition to deal with those issues. So with that, Mark will speak for about 20 minutes, then I'll go over. Mark, I'll turn it over to you.
Thank you. When Jamie asked me to speak on the Roberts case, not having practiced in Maryland, I really didn't have a full appreciation of really what that case stood for and the implications and impact on cases to follow. So I started to research the case, and I learned the issues, and I learned really what the facts were and how the court applied. But it wasn't until I got here at this conference, and there's so many people here from the Baltimore area, and started to speak with them and got a sense of really the concern that this case causes, both on the defense side and the plaintiff side, that I got a full appreciation for for exactly what this matter stands for. And,
Here you go.
okay. I mean, generally when we look at coverage on cases such as lead, environmental, other toxic tort, traditionally, at least the cases I'm familiar with and I've litigated both the two major cases in New Jersey, Owens, Illinois, and Carter Wallace, and both of them define what is continuous trigger. Continuous trigger in the realm of both the toxic tort and the environmental field. And just sort of using that as a backdrop, as we all know, a standard insurance policy is an occurrence-based policy, and when there's an event, we look to see if the insurance policy is triggered within the policy period or not. And the difficulty that insurers have with respect to long-term exposure, both in the toxic tort and in the environmental realm, is there really isn't a true occurrence. There is a period of time in which there is, on a toxic tort side, exposure, and an exposure, and then development of a disease, and ultimately a diagnosis of a disease, which is manifestation. So under the Owens, Illinois decision, they defined the period of time in which the insurers should cover for a claim. And Owens, Illinois stands for the premise, and many states have followed it, and that is that it begins, the coverage period begins at the date where there's the first exposure to a particular insured's product up until the time that a disease is diagnosed or manifests itself. And then they look at the different policies that insured that company or that entity over that time period, and they allocate shares based on time on the risk. And it's easy if you're looking at each policy with the same policy limits, no excess, no stacking, and it's just easy. You look at the number of months that each policy is in effect during that period of time, and you apply a simple pro rata percentage. Similarly, in the environmental realm, although it's a little bit more difficult to define at times, in the environmental realm, you look at the time of the initial discharge by an insured into a piece of property up until the time of discovery of the contamination. Similar to the toxic tort, but different because of the property damage nature of it. And then you do the same thing, time on the risk, number of months of the policy, number of months of that continuous or triple trigger theory, as they call it, and you just do a simple equation, and you do a pro rata share. The difficulty, and this is what Carter Wallace addresses, is when you have different policy limits or different layers of coverage over time. And then you have to perform a calculation, which is an analysis, a weighted analysis based upon the amount of coverage for a particular year, the size of the policies, the number of excess policies. And we do this all the time when we handle environmental cases. And our client, the insurance company, asks us to do a Carter Wallace analysis. What is our risk versus the risk of other insurance policies that are providing coverage over time for a particular insured? That's traditionally the way I've looked at it, and it's a clearly defined continuous trigger period. Can you control it from your end? Well, I'll just go on with without the PowerPoint then. But simply on the Roberts decision, for those of you that practice in Maryland, really understand the basic facts of the case. And it really involves, it's a lead case involving an infant who was born at the tortfeasor, the first landlord's property. She was born at the time that he owned the property, and that occurred in January 1991. On September 1992, was determined to have lead in her system, which reached a peak level of 28. And that occurred in September 1992. The insured in the case, the defendant, sold a piece of property in November 1993. And the child, although diagnosed in September 1992, was treated, and the lead level did not dissipate until into a normal level until August 1995. So it was a total of 55 months from the date of birth to the time that the child indicated a lead level that was acceptable. The insurance carrier in the case was Penn National, and they issued two policies. A policy that began January 1992, continued to January 1993, and then was reinstated or extended until January 1994, which was 2 months after the property transferred to a new landlord. When they instituted suit, the second landlord was nowhere to be found and default was entered. So the initial landlord was the sole defendant at trial and the sole defendant that bore responsibility. And Maryland follows a strict joint and several liability standard for tort liability. What happened in the trial is that there was a $2 million verdict rendered. It was reduced to $850,000 based upon a Maryland cap. And the judge determined that since it's a strict joint and several liability state, that not only did joint and several liability apply to the tortfeasor here, the first landlord, and the first landlord responsible for the entirety of the award, but it would also apply to the insurance policy issued by Penn National, and that it indicated that Penn National would be responsible for the entire amount of the jury verdict, the $850,000. What Penn National did then instead is they went to federal court and they filed a lawsuit both against the plaintiff and the landlord under a declaratory judgment indicating that under the continuous trigger theory and under their fair expectation of what they expected with respect to the policies that they issued, that it wasn't fair, and that the joint and several application was only as to the tortfeasor, but not the insurance contract. And in fact, at the first level of the federal court, the court partially agreed with Penn National, but extended the amount of coverage 24 months rather than 22 months, the full extent, the full length of the two policy periods. So there was two policy periods, each one 12 months, a total of 24 months, even though 2 months of that was after the property was transferred or sold to the second landlord, the landlord that was in default and couldn't be found. And it was appealed up to the Fourth Circuit, and the Fourth Circuit actually took a look at it and said, what is the reasonable expectation of the parties here? The reasonable expectation of both the insurer and the insured. And without an assignment of the policy from the first landlord to the second landlord, and without notice to the insurance company, Penn National, they said the reasonable expectation of Penn National was when the sale of the property occurred, that terminated the obligation of Penn National to provide coverage and beyond that. And the court determined that Penn National was responsible for only 22 months of the total 55-month trigger period here, and shortened it from what the district court held at 24 months down to 22. So it was approximately 40%. Now, the concern, and the concern to both the insured as well as plaintiff's counsel in the case, is now you have 40% of an $850,000 verdict that belongs to perhaps the insured, perhaps another insurer if there's other coverage to be found, particularly if the second landlord is found and the policies that landlord may have had in place are discovered. But that didn't happen in the Roberts case. In the Roberts case, 40% of the $850,000 was left bare, and the first landlord didn't have the assets to cover it, and therefore the recovery to plaintiff was only 40% of a verdict of $850,000, which had already been reduced because of the Maryland cap from $2 million down to $850,000. And as a result, it really defined a nature of the continuous trigger theory, which other states now have begun to adopt. It hasn't made its way to New Jersey, where I practice yet, or New York, where I practice, but it has made its way to other states such as Minnesota and Michigan. And the concerns that you all have, both as plaintiffs and defense attorneys, is you represent insureds that may be bare for certain years and may have to, similar to the Owens, Illinois decision, bear responsibility for being uninsured for a particular time. Here you have a insured that sold a piece of property, assumed that any liability they had with the piece of property would end with the sale, and then under joint and several liability, plus the way that the application of the Roberts insurance coverage decision came about, only was insured for a portion of that. What's also unique about the Roberts decision, and it's something that is really a new way of looking at it, was that it defined also what is the continuous trigger in a lead-based case. Unlike toxic tort cases, where the trigger ends with diagnosis, in the Roberts decision, it extended until the time that the child actually reached the stage of normalcy, which is something that's very unique. We see in the toxic tort cases that we have diseases that generally don't heal itself. They either result in death, or if in the case of a non-malignancy, it's an ongoing condition over time. And you would never go back to normal. Even if it's a cancer case and the cancer is operated on and you go into remission, there's still that potential of reoccurrence. And if it were to apply to a toxic tort case, it would be ongoing trigger on infinitely up until perhaps either the time of death or on someone who doesn't have a fatal disease such as an asbestotic. It would continue really until the person died from perhaps something else. And that's the ramification here, is how the continuous trigger was applied. And it was applied to a period of treatment back down to normalcy. And taking a look at other states in terms of how they apply a continuous trigger in lead cases, so, like I said, some of them are starting to follow Roberts, and some of them are actually looking at their own well-defined, well-established rules. And in New Jersey, it's the date of diagnosis ends the continuous trigger period. In some states, they look at it from an environmental standpoint rather than a health standpoint. And there are certain states that look at the trigger as being the lead in the home or on the walls. When was the lead first placed on the wall? When was the lead abated? And that would be the trigger period. So if a landlord, if an individual purchased a piece of property in which lead already existed, that would begin the first part of the continuous trigger, and it would continue up until the landlord abated and removed lead completely from the premises. And that may or may not be during a time period in which the disease is manifesting itself within the child. Usually it's within the time period that the child is diagnosed, but if you have an individual that moved around from residence to residence and was diagnosed at some point after moving out of the home, is a potential that the date of diagnosis may not fall within the period of time in which lead was on the property, and that would create a gap in coverage as well. Other states look at a single occurrence, the single occurrence being diagnosis. What is the date of diagnosis? What insurance company provided coverage at that time? Or they look at a double occurrence, the date that the child was first exposed and the date that the child was diagnosed, and they look at the two policies and they enter into a pro rata analysis similar to Owens, Illinois, but just looking at and Carter Wallace based upon size of the policy, and they compare the two policies and they put them together and they create a calculation as to which policies cover what amounts. And again, there's a risk of being bare for coverage. But really the Roberts decision and its application to what you all do, and particularly those Maryland attorneys, is scary. And it's scary, as Todd is going to indicate with respect to his presentation, on the obligation of attorneys to both plaintiff's attorneys and defense attorneys to adequately consult with their client to let them know what, if you're a plaintiff's attorney, what may or may not be recovered if there's a verdict. If you're a defense attorney, what you may have to tell your client in terms of uncovered claims and what the insured may be responsible for, because they may not be aware of that. And so in speaking with my Maryland colleagues that I've met here, and the concern and threat that this case has, not just in application of insurance law, but in application of ethical obligations to your client, and again, Todd's going to get into that, it's an important decision and certainly worthy of including in this presentation today, and I appreciate you taking the time to let me talk about it. Thank you.
We're going to continue to zoom right along here. Now you got a little bit of a background in terms of the Roberts decision. What I'm going to do is cover two sort of general steps you can take to avoid problems, to avoid these bad moments. Then I'm going to give you very rapidly two cases to give you a specific example of what the hell just happened moments. And then we're going to give you one actual example of what for the future in terms of what could happen if all of us aren't diligent in terms of the things we're talking about today. And then lastly, I'm going to talk about 4 specific steps you can take to really help prevent these moments. The first one, and you can see it here with our buddy Ben Franklin, about 225 years ago, said the same thing. By failing to prepare, you're preparing to fail. For those of you who were really good when you were kids, the Boy Scouts, the Girl Scouts, it's for both of them, this is their motto, be prepared. So, and that's really part of what we're doing here. We're talking about the issues, we're reviewing the issues. From my experience in Maryland, that, to be blunt, the plaintiffs really do a good job. Brian Brown's firm, the Thallenberg firm, Scott Nevin's firm, they've already got plans, 5-step, 10-step plans to show that Roberts is not truly reflective of Maryland law, and then 10-point plan so that when and if it goes to the Court of Appeals, that the decision of the Fourth Circuit is not, in fact, going to be what Maryland law controls. So the plaintiffs are very much engaged in that process in terms of prep. In terms from the defense firms, what we all have to do, and do it really aggressively, as an example, is make sure early on, remember, failure to prepare is preparing to fail, make sure early on we write, we do it in writing so it's clear to the insured, hey, I'm the defense counsel here. That's my job. I'm going to defend the case. You need personal counsel to advise you about coverage issues, to advise you about the Roberts case. I really can't do that. And you need to do it now, not at the pretrial, for reasons we'll show. So, but that's sort of kind of the first basic step, be prepared. The next step, assuming I don't destroy this, is to be, in terms of preparation, is to be familiar with the tripartite relationship. We were originally going to talk an hour. We're at 45 minutes. Originally, Mark and I were going to give you all a pop quiz at the end for what's the tripartite relationship. So you've escaped that. But it's still something you need to know to be familiar with, just the basics. And you can see there's the insured, the insurance company, and the defense attorney. Here, and this, again, I'll just walk you through this, zoom through this. The relationship between the insurance company and the insured is straightforward. It's a contract, the insurance policy is a contractual relationship. And usually that's pretty straightforward. The insurer controls the defense. In terms of the insured has to assist and cooperate. So usually you don't end up with too many problems there. The second one is the relationship between the insured and the defense attorney. And you notice one of the things I put on there is paramount client. And the reason I say that is, and a number of you know this, but just make sure you're all on the same page, the relationship the defense attorney has with the client is absolutely paramount. It trumps any other relationship. For example, if you are in your office next week and a client comes in and says they want to hire you and you get a retainer agreement and you're hired on the spot, your relationship with that client is absolutely the same as if the insurance company assigned you a case and you represent insured X. You have an absolute fundamental attorney-client relationship which trumps any other relationship. Now, the reason that's important is, and that relates to the insurance company in terms of the defense attorney. And that's where I wrote, as you can see, client, not a client, well, classic lawyer answer, it depends. But I can tell you, in one sense, it's relatively simple and straightforward. In many jurisdictions, if you actually look at the cases, they'll say, hey, the lawyer is representing two clients. One client's the insured, but the other's insurance company. But when you really take a close look at what really happens in the case law, you see very quickly that if it is a two-client state, again, you as a defense attorney, there's no equivocation. Your fundamental duty in a case of a conflict or a disagreement is with the insured, not with the insurance company. So sometimes in some states, it's almost not quite really true. Hey, you got two clients, because one of them, if there's an issue, you set aside. And it's clearly subordinate in terms of that relationship. Now, the next slide will give you, so in some cases, to be blunt, it doesn't fundamentally matter if they're, quote, a client or not the client, the insurance company, because you're protecting the paramount relationship you have with the insured. Now, this slide, and this slide is really important because I want to make a couple of things clear here, which is that even though you have a fundamental duty to the insured, and let's say the insurance company is not technically your client, you still have very fundamental duties, fundamental obligations with respect to the insurance company. I remember, frankly, as a young lawyer, I wanted to try every case I could, and the bigger it was, the better it was. And at some point, you know, the light went on. It was kind of like, Todd, you're not really helping the insured here. You're not helping the insurance company. Where are their interests in this? They're not served by trying every case. So you begin to recognize that. Also, and these are fairly straightforward, what do you owe the insurance company, among other things? These are just some of the duties. Reporting, diligence and thoroughness in the litigation, avoidance of unfair surprise. We all know bad things happen when people get surprised. So that's one of the duties you have as a lawyer, as a defense lawyer. Hey, I got to make sure, I got to protect the insured, and I got to protect the insurance company from surprises, from, oh my gosh, what just happened? Now, there's two here that you may be a little surprised I put. One of them, the first one, is truthful communications. Now, we all know that truthful communications are required as a part of litigation. They're even required to opposing counsel, which is truthful communications. So why did I put it here? The reason I put it here is because there are times, and I'll give you a couple examples of those in a few moments, where there may be information you have that's confidential. And you can see this could happen under Roberts. You meet with your insured, and the insured gives you certain information which could negatively impact coverage. The insured wants you to keep that information confidential and not pick up the phone and call the insurance company, not tell them that. And I'll give you an example from a case on that. That's an area where you are ethically required to not disclose that information without the consent of the insured. So in that kind of case but I just want to be crystal clear, we're not suggesting the case law says you've got to be truthful. Nevertheless, there are times that you have to not pass on simple information. The other one that I put there is actually, this book is Mallon and Smith. This is a 2012 edition of Mallon and Smith. In terms of an authoritative treatise, this is like almost 2,000 pages, and it's volume 4 of 5. So there's 4 other volumes. The language that I use there, which is real friendships strengthened by long-term relationships, interestingly, this scholarly treatise says listen, in terms of the lawyer's relationship with the insurance company, what they say is, listen, that's often can be characterized by real friendships that you have with the insurance adjusters, the insurance representatives. And I'm sure there's a number of people here, you know, if you work with people a year or two, 5 years, 10 years, 15 years, and Mallon and Smith recognizes that you're likely to have, you probably ought to have, some real friendships there, some real trust, if you will. But here's the interesting thing, and I'll show you the case in a second, which is that because you have that trust, because you have that relationship, sometimes you do not reveal certain information to them. It's not because you want to kind of really hurt them. Actually, if you give that information and they rely on it, you could get that claims manager, that claims representative fired. And you can get their company in a lot of hot water. So the smart, the ethical thing to do in terms of protecting your insured, protecting your insurance company, as it relates to issues that are going to come out with Roberts about confidential information that may negatively impact insurance, you don't just willy-nilly turn that over, because it can hurt and it can harm. Now, to give you, and it can lead, if you will, and the example I'm going to show now is this. It can lead to, you would guess, hey, what the hell just happened moment. And I'm just going to go over this very briefly, which is, but it gives you a good example of sort of what to watch out as it relates to Roberts issues. Here's a case, it's a brutal assault. The adjuster first gets the case. The adjuster looks at the facts and says, boy, we got a problem here. We ought to settle that case. And our crack defense attorney, though, however, starts to interview, starts to prepare. In preparation for trial, he meets with his client, and this particular client happened to be named Michael. So he meets with Michael, and he says, hey, okay, tell me, Michael, what happened? Michael describes what happened, and it's pretty clear to him that this is likely, based on his version, the insurance coverage is going to be denied based on willful conduct. Our crack attorney calls the insurance company, writes them a letter, and says, listen, this is a bad case. You ought to settle this case. And by the way, he told me he meant to do it. So the insurance company, of course, gets this information. They get a demand for $22,500 on a $25,000 policy. CNA says, well, hey, maybe it's a bad case, but this demand, in light of the coverage information we have, this is completely unrealistic. Forget it. We're not going to pay that. So, and again, that's based on the information from the lawyer. All right, my example here is, who did he help? The insured, the insurance company, or himself? And my guess is you can guess what's coming. He didn't help anybody. What the hell just happened? And the verdict is $50,000, so that's twice the limit of the insurance policy. The court then subsequently rules in subsequent litigation that the basis of coverage is the insurance company is stopped. They cannot use that as a policy defense. And it really gets worse because at that point CNA is like, well, okay, I guess if we have to cover it, we'll put up our 25. And the court says, no chance. You relied on wrong information. You got information you shouldn't have. Hey, insurance company, even though it wasn't your fault, it was the lawyer who did this. Hey, insurance company, you're going to have to pay twice your policy. And in many jurisdictions, in that kind of situation, the insurance company not only gets sued, but then they have to pay for the attorney's fees for the plaintiffs. So that just gives you a really good example of, hey, what the hell can happen? The court in that case said the standards of the legal profession require undivided fidelity. And again, that's that relationship between the lawyer and the insured. Let's see. This is another example. Again, I just wanted to kind of give you kind of an overview here, which is, in this particular case, and I'm looking at a slightly different area. Remember, we started out by talking failure to prepare is preparing to fail. Well, this is an example of a lawyer who gets a case, and listen, all of us as defense lawyers, you're never going to have the perfect file. And But the reality is you don't want to have files where you're not being diligent, where you're not being thorough. And Roberts makes this tougher now because there's a danger you'll show up at the pretrial settlement conference, and I'll show you in a second, and all the money to settle the case that it was in the past may not quite be there. So we may, those of us who love try cases, we actually like this, I suppose. But again, our job is to protect the insured and to protect the insurance company. And Roberts creates some of those issues. But in this case, the lawyer gets the case, the insurance company offers to, the plaintiff demand is 50. Then, in terms of the insurance company, is good because the demand is getting lower and lower. So the insurance company is saying, oh, we must be doing the right thing. Hey, this is, you wait, they'll be down, and then we'll settle for $8,000. As you can see, that's not exactly what happened in this case. It goes to trial. The insurance company is thinking, hey, we have a pretty good defensible case. Then they get the 290 verdict, and then it's sort of like, oh, what the hell just happened? So part of the issue, again, with Roberts is being proactive, looking at the case, getting information, get what you can, in terms of preventing, if you will, these moments. And I referenced it here, it's not, one of the things we have to watch as lawyers, I always tell people, one letter from the AGC can kind of ruin your whole day. And for those outside of Maryland, AGC is the Attorney Grievance Commission. So what you just want to, I'm not suggesting fear, I'm suggesting preparation. I'm trying to protect my clients. Here's what I'm doing. And that's what they look for. The AGC looks for, are you acting proactively to care for your client, that you really care and you just didn't fluff it aside. And that's something they really focus on. The next slide. Now this is, here's an example that we thought about in terms of a what the hell moment just happened under Roberts. In Maryland, typically, as most of you are here, 30 days or so before trial, you show up at the pretrial conference. All right, let's say it's a year from now. You show up, plaintiff's counsel, pretty good track record in terms of trials and records. Very fine firms, as I mentioned before in Maryland, very fine plaintiffs' firms, very aggressive, really competent lawyers. They show up at the settlement conference and say, all right, you got $2 million policy, we'll be nice. We'll only offer, settle for $1.5 million. And in this example, let's assume you've got real economics of $3 million, which means you got a real issue. Even if all the insurance applies, it's only $1 million. So you got a real excess issue here. And remember, your job is to be fair and truthful and so on with the insurance company, but you're there as defense counsel, making sure that your either singular client or both clients are protected. In this case, the adjuster let's say the adjuster does it precisely correctly. They don't get defense counsel involved. They understand, you're a defense lawyer, you defend the case. They walk in with coverage counsel that says, all right, you can have our 142 and maybe we'll throw you a little extra. The next thing, and I'm telling you, this happens more than you realize. You have an insured in that situation who turns to the defense counsel, an insured who is, you try and tell them, you try and communicate, oh, you don't need to tell me, you're taking care of it. Well, this is the insured who then turns to you and says, hey, you told me I had $2 million coverage. You're my lawyer. What the hell's going on? And that can happen at a pretrial, and I'll tell you from experience, it's even worse after a verdict. So the idea is, what do you do? What steps do you take? What are the examples here? Oops. Now, all right, the couple more minutes. What we did is we sort of put together, sometimes in presentations we have what are the top 10 ways to meet a lawyer. In this case, it's what are the top 4 ways to avoid these moments. And again, these are basic areas. One of them is strong communication with the insurance company, strong communication with the insureds. We really recommend you, and this is really strong, that if you do reports, send them to the insured as well. And here's a funny example, and it happens all the time. when you do the right thing, it protects not only the insured, it also protects the insurance company. Because when you're sending reports that you're sending to the insurance company also to the insured, what it communicates is you're keeping people informed. And you're not in a situation where at the pretrial or, God forbid, after a bad verdict, the client is somehow suggesting that you were sort of in cahoots with the insurance company. At that point, the insurance company would say, listen, we were advised, the insured was clearly advised, it was on the table, we acted properly. So I would recommend giving copies of the reports to the insured, number one. And this, of course, that I mentioned at the start is a big one, which is advise the insured client to get a personal counsel at the start of the case. And boy, I recommend doing it in writing. It helps promote fair and straightforward and good relationships. Diligence and thoroughness of preparation. Now, the reason you see the fat lady up there is, and again, this is another example why you kind of act early, which is that, remember, the plaintiffs are going to take the position, for example, with Roberts, that the fat lady, she ain't sung yet. So, you know, so the idea is now, of course, the insurance companies are presumably going to take a different position. So that's sort of part of, again, if you're prepared, and then what happens, to use our example, when you have a pretrial conference and the insurance company shows up with an attorney on behalf of coverage, or that's communicated before the pretrial, then there's a situation, well, hopefully, if that's the issue, either before or in conjunction with the pretrial, the insured's personal counsel is talking to the insurance company, is doing battle with the insurance company. So that's, if you will, those are kind of examples where, again, you avoid what the hell just happened in terms of prep. Also listed there is sort of the early investigation of the case to avoid unfair surprise. Because again, if you sort of get the pieces on the table, have personal counsel involved, and even if, listen, if the insured rejects your 37 attempts to have personal counsel, you've properly and appropriately laid the record of diligence. And it's beyond the scope of today's discussion in terms of time, but if you want afterwards, Mark or myself can give you some specific answers like, hey, what do you do when you've made a recommendation for personal counsel and they just keep ignoring you? And again, I've covered the basic here. Don't give privileged and confidential information from the insured to the insurance company. And as we all know, there's a whole myriad of issues below that. And then there we go. The last one I said, and because we want to make time, again, we originally had more time. Questions by Mark or myself, answers, we're happy to provide them. Looks like we got quite a few. We want the judges to go forward on time. But by following these guidelines, and you're never going to be perfect, but the idea is if you can show fundamentally you care for your client, you care for the insured, and to be blunt, you care for the insurance company. You want to do right by these people. You really can. You're going to protect the insured, you're going to protect the insurance company, you're going to protect your law license, and you're going to protect the associates who are working under you in terms of preparation and thoroughness. So with that, Mark and I thank you very much.
So we have several questions. Let's go through them. We'll encroach a little bit of time. What happens after you write your client to advise client to hire personal counsel, and the personal counsel wants to discharge you and defend the case? Who pays the personal attorney?
Oh, that's funny. I guess I'm gonna stand. I'll stand and talk like that. Can you all hear me back here? You hear me there? Okay. And again, this is like one of 2 million questions like this. But so I'll give you kind of the big picture answer and then the small picture answer. The big picture is you don't want this letter 32 days before trial, okay? Because I'll tell you what's going to happen. Personal counsel is going to get involved, and agreements you got regarding discovery, how you designated experts, they get out. There's a wonderful quote. I won't read it now, but originally I was going to put it in. There's a wonderful quote that says, by golly, you know, when the case is over, your adversaries, the judges may be compassionate, silent, not go after you, but God forbid an insured who's lost a big case. So part of it is, A, don't get the letter 32 days before trial without expecting somebody to get a microscope and look through your file. I mean, here's the basic answer. The basic answer is there are specific circumstances in Maryland and in other jurisdictions where the insured has a right to what's called true independent counsel. There's a fundamental conflict of interest. There is, the lawyer wants to go direction A. There is a fundamental conflict. In some circumstances, the insured then has that right. I'll tell you from experience and from the law, that's usually not what happens. Usually what happens is personal counsel gets involved and just basically wants, I want everything settled no matter what I pay for everything, and if you don't agree, I'm taking over. Now, I'll tell you another thing. A personal counsel who does that is a fool because they've just taken over the case. So, but I'll tell you generally, if you're prepared and you're diligent and you're doing this, if this happens early on in the case, what we do is we invite personal counsel. Hey, come on over. Look at what we're doing. Look at the steps we're taking. Is there anything else you wanted us to do? We had a horrendous case one time. Sorry, I'm talking too much. I'm sorry.
Two more quick questions. Okay, three more quick questions.
We can do these later.
If under Roberts an adjuster asserts that he has $500,000 in exposure and offers $550,000 in settlement, but there is a verdict against all defendants for $1.5 million, would insureds have personal exposure for the whole million that was left?
Do you want to talk about it or you want me to talk about it?
Well, I guess it would depend upon the jurisdiction, whether there's in our jurisdiction there's a Rover Farms type of case where if the insurance company can settle it within the policy limits and the verdict is in excess of the policy limits, and there's an appropriate Rover Farms letter or excess letter written by plaintiff's counsel to the defense attorney or to the insurance company demanding the policy limits, and the verdict comes in excess of the policy limits, then the insurance company may be on the hook for the excess.
And here, again, these are great questions. Quick answer, but here's the bottom line. This is a perfect question, great question for why you want personal counsel. Let personal counsel and the insurance company and their coverage counsel do all the battles they want. You as defense counsel stay the hell out of that circle. Somebody says to me, how much money am I going to have? Is there an exposure of bad faith? What's my exposure? I don't know. I don't do coverage work. Talk to your personal counsel. I'm here to try the case. In terms of who covers what and how they cover it, and you got a letter that says that, I am not able to advise you. However, I'm prepared to go to trial because you don't want to be in that situation and not prepared to go to trial, because if you're not prepared to go to trial, then personal counsel's job is to put the knife to you and say, oh, and again, remember I said why it even helps the insurance company that the letters that you're writing go to the insured? Because the insurance company says, hey, listen, no surprise here. We could clearly they were informed.
Thank you.
I really care about this stuff, so forgive me.
So we have lots more questions, but we are jammed up for time, so we're going to have to move on to our judicial panel now. I want to thank Todd and, God, am I going to bring trees? Mark, thank you. Sorry, Mark, for their time and their effort in this presentation. It was great, very informative, and they both indicated they're willing to stay by and answer your questions at the next break if your question didn't get read up here. And so with that, we'll ask for Judge Rosenbaum, Judge Smith, and Judge Gordy to come on up.